Good evening and welcome to the Banco Court for tonight's lecture, the second in the Selden Society Australian Chapter's 2019 lecture series. And a particular welcome to those who are joining us live streamed from Townsville for the lecture this evening. Tonight, on the topic of Oliver Wendell Holmes and the First Amendment, we're very pleased to be joined by Lionel Hogg. Lionel will be well known to many of you here in the room, and I'm sure to some of those watching us from Townsville. He holds the degree of Bachelor of Laws with honours from the University of Queensland and a Bachelor of Civil Laws from the University of Oxford. He was admitted as a solicitor here in 1989 and was a partner at Fays Ruthning and later Allen's from 1993, and since 2002 has been a partner in the firm Gaydon's. He's got a very broadly based commercial practice, including advisory and transaction work for both government and private sector clients. His topic tonight, of course, is an enormous one. The lifespan of Oliver Wendell Holmes takes us from service in the American Civil War through to the Great Depression. And I'm sure that Lionel will be able to manage the length and width of that topic for us in a most interesting way. So my most important task then is to get out of his way so that he can give us that lecture. And so I'd ask you to welcome in the usual way, Lionel Hogg.
Thanks, Justice Bradley, and it's an absolute privilege to be asked to speak tonight and to give this Selden lecture. The list of founding members of the Selden Society back in 1887 includes Oliver Wendell Holmes, then of the Supreme Court of Massachusetts. In 1887, when the Selden Society was formed, Holmes was 46 years old, and already at that time he'd achieved more than most great lawyers would in a lifetime, including writing a book, which is still in print, first testing some pretty fundamental concepts that ultimately would quite profoundly change and shape jurisprudence of the 20th century. Yet in 1887, Holmes was not even halfway through his long life, and his distinguished legal influence was just starting. In the ensuing 48 years, Holmes would write 1,000 opinions for the Supreme Court of Massachusetts, of which he'd eventually become Chief Justice. And then he'd embark on a 30-year journey as an Associate Justice of the United States Supreme Court. Now, as Justice Bradley's referred to, the volume, the complexity and authority of his contributions can't fairly be summarised in a single lecture. He was a lifelong sceptic and a model of judicial restraint. His legacy included validation on many of the large issues of his time, particularly the protection of freedom of expression and the permissibility of social welfare legislation. And of all of his opinions, nothing defines his life's work better than his approach to the First Amendment. Modern First Amendment law can be traced directly to a series of eloquent dissents of Holmes in advocacy cases, in subversive advocacy cases in the aftermath of the First World War, including Abrams in the United States, which I'll discuss in some detail. This is the centenary year of the decision in Abrams in the United States, his most famous dissent. And what I'm going to try to do in this lecture is examine a man of some complexity and apparent contradictions through the prism of his approach to First Amendment cases, to the free speech cases that he looked at, and seek to identify, if I can, what contemporary lawyers might learn from Holmes's life experience, from his philosophy, and from his very eloquent contributions to the law. So what I'm going to do is firstly frame the discussion by looking at the history of the First Amendment. So we've got the law in our sights. I'll then examine Holmes's background and his influences, his personal and his professional influences. I'll consider Holmes as a lawyer and as a judge, and then I'll try to bring that together and examine his developing approach to First Amendment cases as a measure of the individual and as a measure of his influence. So the First Amendment, personal freedoms, of course, are all important and they're all relative and they're all interdependent. But there can be no freedom more important for individual self-development and for collective self-determination than freedom of thought and expression, or free speech, we'll call it. Free speech, of course, is the facilitator of all other freedoms, and it's the foundation of deliberative democracy. Civil society, of course, can have legitimate disagreements about the limits of free speech and the public or private sanctions for various categories of antisocial speech. But robust protection of free speech is absolutely vital in the ongoing search for truth and for good government, and also at a personal level to help realise our full humanity and allow us to understand others. As we know, common law jurisdictions have traditionally protected personal freedoms by omission. Citizens are free to do absolutely whatever they like, except to the extent that a law says otherwise. Free speech is therefore a common law only incidentally protected, including by principles of legality, requiring statutes to be interpreted to preserve fundamental freedoms where possible in the absence of clear intentions to the contrary. In some jurisdictions, of course, some freedoms, including free speech, have been elevated to justiciable rights through constitutional or statutory bills of rights, and the First Amendment is one of those. No right seems more fundamental to American law or American culture than free speech. It's the crowning achievement of American liberty in so many ways. The original Constitution of the United States did not at all contain any guarantee of intellectual or religious freedom. And fairly quickly there was repeated condemnation in the state conventions, and the Bill of Rights was put together and proposed for adoption by the states. And when the Bill of Rights was adopted in 1791, the First Amendment was the first part of it. And to remind you, I'll read it to you in full. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. So the First Amendment by its terms applies to laws enacted by Congress and to government agencies and not to private actions. And through the interpretation of the 14th Amendment, which is the Equal Protection Clause, it applies to the states as well. The start of it wasn't necessarily as one might, looking back, think that it may have been. Firstly, the Supreme Court didn't and has never developed any comprehensive theory on what the constitutional guarantee actually means or how it should be applied in concrete cases. Its justification has been underpinned by different values at different times, which the courts have variously emphasised depending on the issues that have been in dispute. They've particularly emphasised values of the ongoing search for truth and good government and participation and decision making. But there's no comprehensive theory that has been articulated as to why it's there. From the get-go, there was a dispute about its meaning as well. It wasn't interpreted literally. The general view was that the Bill of Rights wasn't intended to lay down any novel principles of government, but simply to embody the guarantees and the immunities that were inherited from the English law, subject to the exceptions that were inherited from the English law. Now, as you may remember, under the English licensing, the famous English licensing system, all printing presses and printers were licensed and nothing could be printed or published without the prior approval of the state, something that was very controversial and resisted very strongly. And the great struggle for liberty, as we may recall, for the liberty of the press, was for the right to publish without a licence what for a long time could only be published with a licence. That system eventually expired in 1694, and the relevance of that is the common law picked it up and the common law accepted the position at that time. And the common law view at the time of ratification of the Bill of Rights in 1791 was as expressed by Blackstone. Blackstone said that the liberty of the press is essential to the nature of a free state, but this consists in laying no previous restraints upon publications, and not in the freedom from censure when published. There was no restraint on freedom of thought. The crime was in the expression of bad sentiment. In other words, you could think anything you want and say anything you want, but the minute you said it, if it was problematic, you had a problem yourself. Blackstone categorised these things as offences against the public peace: blasphemous conduct, immoral conduct, treasonable conduct, seditious, scandalous libels. All those sorts of things were legitimately aspects of speech which could be restrained. And offences included anything at all which tended to provoke or excite others to breach the peace. So Blackstone said that the punishment for dangerous or offensive writings of pernicious tendency was necessary for the preservation of peace and good order of government for religion, and the only solid foundation of civil liberty. So that was the prevailing view. At the time that the First Amendment was enacted, it meant that you couldn't be stopped from publishing, but you were liable for the consequences of what you published. And this continued to apply despite some controversy with the Sedition Act in the late 18th century, which punished anybody who'd write or publish anything that was false or scandalous about the state. It was an act that was brought in by the Adams administration to prosecute its opponents, essentially. And when Jefferson became president, he pardoned those who were still serving sentences, and Congress actually repaid their fines. But despite all of that, the Sedition Act experience didn't change the view of the First Amendment. The First Amendment did not mean what it apparently says. This view just continued. In a case in the Supreme Court in 1907 where Holmes was the judge who wrote the unanimous judgment of the court in Patterson and Colorado, Holmes reinforced that the main purpose of the First Amendment was to prevent all such previous restraints upon publication as had been practised by other governments, and they do not prevent the subsequent punishment of such as may be deemed contrary to the public welfare. In criminal cases, the other thing that's important to remember in criminal cases is that courts also imposed a parallel bad tendency test, that words that could have a tendency to produce a libel or to produce insurrection or other prescribed conduct, that in itself, the existence of the tendency, was a sufficient basis for a conviction. And of course, when you think about it, a bad tendency test fails absolutely any measure at all of a law that can be administered equitably, and it led to some quite arbitrary and discretionary enforcement. One very famous critic said that to know what you may do and what you may not do, and how far you may go in criticism, is the first condition of political liberty. To be permitted to agitate at your peril, subject to a jury's guessing about motive or tendency and possible effect, makes the right of free speech a precarious gift. But this was the position in the United States. And as late as the 1920s, the United States Supreme Court had never once struck down any law or government action on First Amendment grounds. To the contrary, what it had done was it had repeatedly affirmed convictions and imprisonment for dissidents who were merely speaking out against public government policies. Now, as we know, in contrast, Australia doesn't have a Bill of Rights. Free speech is protected by an implication from the text and structure of the Constitution. We don't have any absolute protections, and Parliament assesses the importance of legislative action. But laws in Australia with legitimate objects, such as national security laws, may substantially infringe freedoms. So that's the background of the First Amendment, its history up to the First World War, which is the relevant period that I'm going to talk through this evening. But I'd like to now step back and introduce Oliver Wendell Holmes, or Wendell as he was known to his family. He was born on the 8th of March in 1841 in Boston, Massachusetts. He was the firstborn child of Amelia Lee Jackson. His mother was an abolitionist daughter of a prominent Boston lawyer and judge. His father was an equally famous man with the same name, Oliver Wendell Holmes. Dr. Oliver Wendell Holmes Sr. was a physician, a professor at Harvard Medical School, a famous writer of light verse, and a leader in Boston intellectual and literary circles. Dr. Holmes published the very popular The Autocrat at the Breakfast Table, which was a series of essays and poems in the Atlantic Monthly, a publication which is still going. In fact, a magazine, The Atlantic, is one that Dr. Holmes co-founded and named. Young Holmes's early influences were very philosophical and literary, not surprisingly, with a literary doctor father in the house. He was a lifelong friend of novelist Henry James. He was mentored by the family friend Ralph Waldo Emerson. He was exposed to published intellectuals on a daily basis. It would have been an interesting existence. His schooling was at Dixwell's Latin School. I say it was at Dixwell's Latin School because Mr. Dixwell, the founder of that school, ended up being his father-in-law. It was a school established by his future father-in-law, and there at school he studied Latin, Greek, French, German, Greek and Roman history, and mathematics. He went to Harvard College. He was an unfailingly gracious and polite person, witty and lively in company, but a very private person. He had a quite awkward relationship with his father, largely through personality differences. Although both of them were great conversationalists and absolutely fascinated by ideas, Holmes Jr was pretty serious. He was driven, and in many respects he was a loner. In fact, Holmes saw his father as something of a dilettante, because his father had written poetry that belittled his son's introspection. One of his poems says, the person in the poem who was referred to as the astronomer was, quote, looking at life as at a solemn show where he is the only spectator. Thanks, Dad. His father also used his war experiences as fodder for his writings. When Holmes Jr was off in the Civil War, his father would keep writing about him, and he followed him around the country, tried to find him. Holmes might also have felt some pressure to live up to the high expectations of being the son of Dr. Holmes. In fact, when announcing that he was going to the Harvard Law School after he'd returned from the Civil War, he was told by his father that a lawyer cannot be a great man. That was all his father said to him. As an undergraduate, Holmes published works on Dürer's engravings and Plato's philosophy. He explored the nature of evolution, science, idealism, and duty. A pretty stunning interdisciplinary examination by a teenager. He enlisted in the 4th Battalion of the Massachusetts Volunteers in the Union Army in 1861, before he'd actually graduated Harvard, although he did eventually graduate Harvard. He served for 3 years as a lieutenant in the Civil War. He saw much action, including a number of very notable battles. He was wounded 3 times, shot 3 times, twice nearly fatally. He suffered a near-fatal case of dysentery as well. And his final wound actually saved him from the Battle of Gettysburg, in which half of his regiment and 10 of the 13 officers in his regiment were killed. Holmes, as a result of that, possessed a pretty bleak worldview forged by the ravages of war. The experience profoundly affected his concept about duty, right and wrong, the futility of war, the survival of the fittest, a fairly Darwinian worldview, and Darwin was the social science of the time. Holmes regarded himself as an accidental survivor and strongly believed that he was duty-bound to make something of himself, and he became obsessed with the law. Because high achievement was always expected of him, including by himself, he had a driving ambition, relentless focus to be the best and to be recognised as such. He possessed an outstanding work ethic. He was admitted to the bar in 1867. He joined a Boston law firm and had a busy commercial and admiralty practice. He regularly visited London, forming close intellectual friendships with some leading British lawyers and other thinkers of the times. He married the daughter of his school teacher in 1872, Fanny Dixwell. They had no children. His journal entry on his wedding day says, quote, married, sole editor of Law Review. At least marriage was first. He had a 57-year marriage, so that didn't blot the copybook, obviously. and that lasted until Fanny's death in 1929. Although he had a busy practice, he maintained independent scholarship, editing various legal books, writing dozens of law review articles. He developed a series of essays for the American Law Review, which presented a systemic analysis of the common law. And those essays would become a series of lectures, which he then published as The Common Law in 1881, just before his 40th birthday. He had a superstition that if he hadn't done anything meaningful by 40, then he weren't going to do anything meaningful. He became a professor of law at Harvard Law School, but that didn't last very long because he was invited to take an appointment as a justice of the Massachusetts Supreme Judicial Court in 1882. He served as Chief Justice of that court for 3 years, from 1899 until his appointment as an Associate Justice of the Supreme Court in December 1902. Now, Holmes was not religious. He was not political. He famously did not read newspapers, probably great advice. But he was profoundly interested in ideas and open to opinions at odds with his own. He was apparently a memorable companion and conversationalist, and a keen and stylistic correspondent. In fact, his correspondence is famous. He wrote over 10,000 known letters in his lifetime. He had 58 years of correspondence with Sir Frederick Pollock and 15 years with Harold Lasky. Each of those fill over 2 published volumes, and they're notable, if you flick through them, for their intellectual quality. Despite his civility and his wide circles of acquaintances, Holmes had very few close friends, although he was frequently surrounded by young admirers in later life. Most prominent of those were Felix Frankfurter, Harold Lasky. Lasky, in fact, was something of a surrogate son to Holmes. He was over 50 years Holmes's junior. They're quite the odd couple. 2 absolutely towering intellectuals. Holmes, the establishment conservative, although he had some progressive judgments, but as conservative by demeanour. And Lasky of the activist left. Lasky would, of course, go on to, in the Second World War, be chairman of the British Labour Party. And Lasky, even while he was in the United States, would become the subject of a Bureau of investigation file opened by a very young and ambitious J. Edgar Hoover. Holmes's life spanned a rapidly changing economic and social environment, and it's important to remember what Holmes went through when we consider what he decided. He went through civil war, personally, industrialisation, internationalisation, a world war, and the growth of centralised government. He's one of the few Americans of his generation to have had an intimate acquaintance with English society at the height of the British Empire. He described his own generation of young men as one brought up in an atmosphere of investigation, rather than having every doubt answered by some creed. So in short, personally, Holmes was gifted, privileged but worldly, inquiring, driven, interdisciplinary and literary. He had a sense of duty and purpose, perhaps destiny, and led a life distinguished by service. Holmes was as nuanced a personality as the legal system he identified. How else could he ideologically polar opposites such as Lewis Brandeis and Antonin Scalia both be described as progeny? As a judge and a lawyer, Holmes's judgments and legal philosophy continually were refined and developed. Everything was a work in progress. When he wrote The Common Law, he regarded it not as his view of the law, but as a work in progress. The Common Law was written, of course, before Holmes was a judge, and it's arguably the most original work of legal scholarship by an American. Holmes's views, as I said, will be continually refined, but what comes out of the common law are a few things. A pragmatism, born of an understanding of the evolutionary nature of the common law. A belief that rules and principles themselves are always subject to development. In a Supreme Court case in 1917, he said that the common law is not a brooding omnipotence in the sky. He famously said that the life of the law has not been logic, it has been experience, the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. The substance of the law at any given time, according to Holmes, pretty nearly corresponds with what is then understood to be convenient. But of course its form and machinery is informed by history. In The Path of the Law, an article that he wrote in the late 19th century, he developed what he called his bad man theory of the law, where he said if you want to know what the law and nothing else is, you must look at it as a bad man who cares only for the material consequences which such knowledge enables him to predict, and not as a good one who finds his reasons for conduct, whether inside the law or outside of it, in the vaguer sanctions of conduct. So in short, what Holmes did is he wrote a very influential book which completely rejected natural law. The traditional view that Blackstone and others had espoused, that law rains down from on high, that there were some immutable principles through which everything could be determined logically. He said the law did not begin with a theory. Logic alone does not explain legal developments and is incapable of responding to a rapidly changing economic and social environment. In the common law, he looked at various systems. He looked at the English, the Roman, the German, the Scotch systems. Historically, he said all of those systems had demonstrated over hundreds of years that even when rules were maintained, their rationales and their consequences changed. Precedents, according to Holmes, often survive long after their use or reason continues. Real legal developments are unspoken. They're legislative by judges, reflecting convenience and adaptive public policy, but within the framework of practices and traditions that the law has. Judges create new reasons for old principles and new principles for old reasons. So while the law does, in a certain sense, measure legal liability by moral standards, by necessity, it continually transmutes moral standards into objective ones. Now, for First Amendment purposes, importantly, Holmes was not philosophically grounded at all in individual rights. In fact, quite the contrary. He never framed anything as a right. He upheld personal freedoms, individual responsibility, and the right of people through the state to impose communal will. He was accused of having a Darwinian might is right philosophy. I would say it was not a might is right philosophy as much as a might is generally lawful philosophy, even if one thinks that it's morally wrong or hopelessly misguided. He recognised the inherent problem with entrenching rights is that every right is grounded in a value, and values change over time and over place. And they're the fighting faiths that Holmes would famously refer to in the Abrams decision. So he was appointed to the court. He was appointed to the court by President Theodore Roosevelt, who admired Holmes's military service and became good friends with Holmes and Fanny. They used to dine frequently at the White House, attend the theatre together. They did that until Holmes decided the case against the president's wishes, because Holmes was nobody's man. His relationship with Roosevelt soured when Holmes wrote a dissent in the Northern Securities Company case. It was a substantial railroad trust case, a railroad trust that was supported by JP Morgan. There was a concern that it would take over, would become the largest company in the world, and Holmes dissented. He thought that the Northern Securities case was a simple matter of statutory interpretation. And in that case, he actually also outlined his theory of dissent. He said great cases, like hard cases, make bad law. For great cases are called great, not by reason of their real importance in shaping the law of the future, but because of some accident of immediate overwhelming interest, which appeals to the feelings and distorts the judgment. Now, Holmes was known as the great dissenter, but the truth is that he dissented only at about the average rate for appellate judges in his time, over all time, in any common law jurisdiction. Very average record of dissent. He said, I think it's useless and undesirable as a rule to express dissent. But when he dissented, he made a point. Holmes's dissents were never disrespectful to his colleagues, and they were often expressed with regret. His dissents were actually significant not for their quantity, but for their quality. His rhetorical flair contributed to, I think, the vindication of many of his dissents. He dissented with a style and with an intellect that demanded attention. Now, there's no doubt, of course, that dissents can be sometimes self-indulgent or petulant or attention-seeking or small-minded or just plain wrong. But an intelligent dissent isn't purposeless, and this was clearly Holmes's view, if it establishes the groundwork for future developments of the law. And this was part of Holmes's pragmatism. He inherently recognised that future courts may view future cases through a completely different lens because of his view that values change, that nothing is set in stone. Holmes had the rare combination of being brief, fast, poetic, and enduringly right. He wrote his judgments at an upright desk because he believed that standing was conducive to brevity. He was so fast, in fact, in turning around opinions that Louis Brandeis wrote to Felix Frankfurter, quote, "He doesn't give a fellow a chance, he shoots so quickly." I think that might have been part of the intellectual leadership as well to control the agenda. His reputation as a progressive and a great dissenter was forged in a case in 1905, Lochner and New York. The Lochner era cases lasted until the 1930s. They were a series of cases where the federal court struck down over 150 pieces of employee protection legislation regulating work hours and child labour and the right to join unions and those sorts of things. And those cases were struck down under the Due Process Clause of the Constitution. And in Lochner, the majority struck down a New York labour law that required bakery employees to work no more than 10 hours a day or 60 hours a week. And that was struck down because it violated the Due Process Clause because, according to the majority, it infringed freedom of contract. You had the freedom to contract for 70, 80 or 90 hours a week. Holmes didn't like that. In 3 short paragraphs, he dissented. The most famous line from the dissent is that the 14th Amendment does not enact Mr. Herbert Spencer's social statistics. More importantly, the dissent actually set out Holmes's theory of the Constitution. He said that a constitution is not intended to embody a particular economic theory, whether of paternalism and the organic relation of the citizen to the state or of laissez-faire. A constitution is made for people of fundamentally differing views. And that will come back when we talk about the First Amendment cases. Now, of course, there were criticisms of Holmes, and because of his influence, the greater the influence, the greater the criticism. He was controversial in part because he wasn't a conventional lawyer. Richard Posner perhaps gives the best illustration when he wrote about the Lochner dissent, the one that I've just spoken of. Posner said that the dissent wouldn't have received a high grade in a 1905 law school examination. It was not logically organised, not thoroughly researched, not scrupulous in its treatment of the majority opinion or of precedent. It is not, in short, a good judicial opinion. It is merely the greatest judicial opinion of the last 100 years. Now, aside from historical revisionism, which seems to be fashionable, substantive criticisms of Holmes's jurisprudence and his judgments really come from advocates of natural law, proponents of objective concepts of right and wrong. And nothing, absolutely nothing in terms of coherence or meticulous detail and reasoned criticism or scholarship compares with a wonderful polemical study written by Albert Alschuler in 2000 called Law Without Values. And in essence, it amounts to an attack on Holmes's scepticism and his pragmatism. He says that Holmes had a power-focused philosophy and a pretty brutal worldview that shaped his understanding of the law. He thought that he was too affected by the Civil War and profoundly transformed by it, and pervade a sort of social Darwinism that was unattractive. He viewed Holmes's deference to the legislature as a might makes right philosophy. And he didn't like the bad man theory either, because he views the bad man theory as not capturing what the law means in civilised societies. It obscures the reason for observing the law out of a sense of mutual obligation. He also said that Holmes produced a legacy of brooding sceptics. Now, that amounts probably more to a lament of Holmes's influence and disappointment that some following Holmes's scepticism were possibly less equipped than he to use it. But there is considerable merit, of course, to the view that we need to recognise how to blend ethical and empirical judgments. But when the law is value-laden and the authors of the law are judges, this does raise legitimate or issues of legitimacy. So now we come to the core of the First Amendment cases that Holmes had to face. There's a perennial conflict between order and freedom which every society needs to negotiate. On any view, national security and the management of existential threats is a core function of every state. There's no doubt that the major wars of the 20th century were very, very real existential threats. And there's no doubt that successful prosecution of wars of that sort, requires the collaboration of citizens and some unity in national purpose. So probably much is and can be excused in wartime that in times of peace would be unacceptable. Existential threats necessitate action, but this of course begs the question whether the threats are existential. And history, as we all know, demonstrates that the refrain national security is frequently invoked, even in good faith, for convenience rather than for necessity. Speech at any time can be controversial, and in wartime, speech can be incendiary. Under the pains of war, it's perhaps easy to overlook the truth that free speech is not merely an individual interest, which must necessarily be ceded to national interests such as safety and security. Free speech is also, as we well know, a social interest upon which our whole system of government is grounded, and which, particularly in contested times, such as war, allows government actions to be tested against their stated objectives, against proper purposes, and against community preferences. Australian courts were faced with similar wartime challenges. As the Chief Justice recently noted, World War I weighed very heavily on members of the High Court of Australia personally, with 4 sitting judges losing sons to the war. Not surprisingly, no Australian wartime regulations, including speech restrictions, were ever invalidated during the First World War. The High Court in Australia took a very broad approach to government power and upheld various restrictions as within the defence power. Holmes's view of the constitutional protection afforded by speech changed over time. As I previously mentioned, in 1907 in Paterson and Colorado, he merely parroted the view that had been in place since 1791, the Blackstonian view, the no prior restraint view. That premise held for Holmes long before his appointment to the Supreme Court. As a justice in Massachusetts, in a decision subsequently affirmed by the Supreme Court, he held that no person had the constitutional right to make a speech on Boston Common in defiance of an ordinance requiring a permit from the mayor. The matter wasn't even considered at that time to be a constitutional issue. If the legislature had the right to stop the public using Boston Common, it could surely do the lesser thing of stop them speaking on Boston Common. Holmes took a similar view in employment cases, holding that a person can't complain when taking on employment on the terms offered to him. He famously said the petitioner may have a constitutional right to talk politics, but he has no constitutional right to be a policeman. Now, the First World War was the catalyst for the Supreme Court and for Holmes to reconsider the meaning of the First Amendment. And some context is required for this. The Espionage Act and the Sedition Act, which was an amendment to the Espionage Act, created numerous war-related offences, as you would expect, and similar to the War Precautions Act in Australia, including panellising spying activities, protecting ships in harbours, all the things that you'd expect. Relevantly, the Espionage Act criminalised a wide range of written and spoken activities around opposition to the war and to discouraging people from enlisting. And it regulated publications and it regulated the mail. It used language of disruption and disloyalty and contempt for the form of government, hindering prosecution of the war, urging curtailment of production, advocating, teaching, defending or suggesting prohibited acts. Essentially what it did was elevate the expression of any dissent to a criminal offence. It included fines of $10,000, a fair bit of money in the early 1900s, and 20 years imprisonment. The postmaster could also ban publications on evidence satisfactory to him, and it was a him. Now, there's no doubt that the business of war was part of the whole nation, from munitions factories to military apparel, from military supplies to food. The entire economy had been geared to the war. And there's no doubt that there were Germans and other enemy agents deployed on American soil. So any attack on the cause was seen as an attack on the country. It was unpatriotic, it was dangerous. Despite this, of course, there were significant pockets of criticism and resistance, religious opposition in particular, questioning of the wisdom of the cause as the war was prolonged, questioning of how long this war should go on for. And as an immigrant nation, and this becomes important, as an immigrant nation, there were a multitude of internal views. During the war, the courts were extremely swift to uphold the various prosecutions and obstruction charges, with the exception of Judge Learned Hand, who was then in the New York District Court. He was the lone holdout at the time. In the Masses Publishing case, Hand enjoined the postmaster, a very censorious man, from banning a so-called revolutionary publication that was critical of the war. Hand also rejected the bad tendency test. His decision, as articulate as it was promptly stayed and overturned on appeal, and it was consigned to the dustbin of history. The Circuit Court of Appeals substituted the bad tendency test, which district courts routinely followed. There were over 2,000 Espionage Act prosecutions during the First World War, including for things like advocating heavier taxation instead of war bonds, stating that conscription was unconstitutional, even though the Supreme Court had never considered it, saying that a referendum should have preceded the declaration of war, for criticising the war as being against religious teachings. There was a prosecution for discouraging women from knitting socks for soldiers. There was also a prosecution against some producers who produced a war film on the birth of the nation, a period some 150 years before, but it was prosecuted on the basis that the film itself was said to arouse antagonism amongst American people to their very important ally Britain. So the prosecutions were the product of a very, very divided political and social environment. Some of them were undoubtedly in good faith, others were undoubtedly self-serving. Federal authorities were brimming with officials at all levels of seniority, absolutely committed to crushing dissent. There was considerable regulatory activism at the time from the Bureau of Investigation, from the Department of Justice. The Attorney General, Mitchell Palmer, issued a direction that prompt and aggressive enforcement of the Espionage Act was of the highest importance, stating with the caveat that it should be administered with discretion which does not seem to have been used very often. That environment had the effect of empowering district attorneys to act, and it really gave them the option of enforcing the law, laws carrying 10-year prison terms. National security at the time was supported by a degree of ideological zealotry. The Attorney General Palmer wanted to run for president in 1920. He wanted to do that on the back of his tough national security stand. Ultimately, his raids on dissidents in late 1919 backfired and he couldn't run. J. Edgar Hoover had come on the scene at this time. He was a very young man, but he was opening his files. He was getting his processes in place for his later skills to be put to full use. He was making his mark on the Bureau of Investigation. He opened files on academics and radicals who expressed any criticisms. Two of these people were close confidants of Holmes's. One of them was Harold Lasky. There were cautionary views in the federal administration. There were some prominent ones, but they were largely ignored for the expediency of public prosecution, and so on. Unfortunately, judges went along for the ride. There's a veritable catalogue of convictions where the judgments or the sentencing remarks are channelled by narrow subjective judgments against agitation of any sort. In fact, Holmes, in a letter to Lasky, commented that, quote, "The federal judges seem to me to have got hysterical about the war. I should think the President, when he gets through with his present amusements, might do some pardoning." The Supreme Court didn't get to hear any Espionage Act cases until November 1918, so right at the end of the war. The first of these, I'm going to discuss, there are a number of them, but I'm going to discuss four. The first of them was Balzer, or the United States and Balzer. The Balzer decision is a very interesting one. It involved 27 socialist farmers from South Dakota, and they were protesting draft quotas. They claimed that South Dakota had a higher draft quota than it should have. The problem was that more men had been counted because more men in South Dakota had also enlisted voluntarily. But the socialist farmers argued that they'd been targeted for their political beliefs and for their German heritage. They petitioned the governor, threatening that failure to meet their demands, whatever they were, would spell defeat, quote, "for you and your party and your little nation." I don't know how existential that sort of threat from a South Dakota farmer is, but they were charged with obstructing the draft. They were convicted by a jury. They were jailed for between 1 and 5 years. The Attorney General was very keen to get the Supreme Court's approval for the Espionage Act, and he requested an expedited appeal. So the judges heard this appeal, and in conference they voted to dismiss the appeals. But Louis Brandeis was concerned, and he appealed to Holmes to see if he could use his intellect and his sway to overturn the convictions. So what Holmes did was he wrote a dissenting judgment, which actually at this stage would have extended the First Amendment beyond the limits of the prior restraint doctrine to protecting against subsequent punishment, except in the case of very great emergency. They were the words that he used in his judgment. The Chief Justice actually agreed to join the opinion, so there were 3 judges who were ready to start using the First Amendment for the first time. But the reasoning was never handed down. The government confessed error and asked for the case to be returned to a lower court. One scholar has suggested that the government got wind of the dissent and has some evidence for that. Government documents later disclose that the department feared embarrassment. The other war cases were all heard by the Supreme Court after the war in a 9-month period in 1919. Now, you also need to understand the political environment in 1919. The war was over, but the political environment in 1919 was possibly even more hostile to free speech than it had been during the war. A society that's accustomed to conflict doesn't really stop viewing every public act through the prism of good and evil. And 1919 was a year of unprecedented fear and upheaval, one of the most fractured and tumultuous years in the United States history outside of war, world or civil war. There was a confluence of economic and social and political conditions in America at the end of the war that produced what could only be described as an ecosystem which is eerily resonant of current times. An ecosystem of fear, ignorance, prejudice, grievance politics, opportunism, misplaced idealism. It was a civil society under severe stress. Economically, the country that had been geared for war had to stop, and it had to gear itself up for peace. The loss of military contracts and production created massive social dislocation, massive unemployment. There were 4 million men returning from the war who didn't have jobs. There was widespread poverty, stagnant wages, spiralling inflation, violence and terrorism on an unprecedented scale, race riots in many states, pandemics of lynchings of African Americans by mobs. There were 64 lynchings in 1918 alone, including pregnant women and black soldiers in uniform. In February 1919, officials arrested 14 Spanish immigrants on charges of conspiracy to assassinate President Wilson. In March and April, the police announced the discovery of violent plots to overthrow the government in a number of states, Seattle, Chicago, Pittsburgh. There were bombings. There were bombings almost every second day in the homes of the rich and powerful. Bombs in Philadelphia destroyed the home of the Chief Justice of the Pennsylvania Supreme Court, the acting superintendent of police, the president of the Chamber of Commerce. Mitchell Palmer, the Attorney General's home, was completely destroyed by a bomb. On one day, 30 letter bombs were sent to prominent Americans in a single event. Some of them were intercepted. One of those bombs was destined for Oliver Wendell Holmes. In 1919, labour strife was a daily occurrence. In the year, there were over 3,600 strikes. Grievances over labour conditions were backed by the industrial workers of the world, resulting in the opponents characterising everything as a dispute in existential terms. And there was the first Red Scare. It was in full flight, with Bolshevik sympathisers targeted by the Overman Committee, which released a list of academics and other radicals said to be enemies of the state. Add to that list the start of Prohibition, a global flu pandemic, a few severe weather events, and even the World Series was fixed. So 1919 was a pretty tumultuous year. In short, there was really growing anxiety that the American way of life was being threatened by immigrants and by Bolshevik sympathisers. So we come to three cases that the Supreme Court decided in that year, resulting from events that had happened in the previous year. The first was Schenk in the United States. Charles Schenk was the General Secretary of the Socialist Party in Philadelphia. So socialists were on the nose in 1919 for the reasons I just described. Mr. Schenk printed and distributed 15,000 leaflets declaring that the draft was unconstitutional, it was involuntary servitude according to him, and he urged that the draft not be obeyed. And he mailed these leaflets to people who were called up for military service. He was charged with various conspiracy offences, calculating to cause insubordination, obstruction of the draft, those sorts of charges. It was a pretty clear case of incitement to resist enlistment. The jury convicted him, sent him to jail for 6 months. And Holmes wrote for a unanimous court. And Holmes upheld the convictions. So there were 9 judges who were prepared to convict. There had been some movement though. Holmes said that the First Amendment was not confined to previous restraints, so he moved to where he'd been in Balzer if Balzer was ever published. He said that the character of every act depends on the circumstances in which it's done. He made the famous line that the most strident protection of free speech would not protect a man in falsely shouting fire in a theatre and causing a panic. According to Holmes, the question in every case is whether the words used are used in such circumstances and of such a nature as to create a clear and present danger that they'll bring about the substantive evils that Congress has a right to prevent. It's a question of proximity and degree. If you review those words quite subtly, you'll see that it wasn't clear and present danger in an existential sense. It was clear and present danger in preventing the objectives of Congress. So Holmes still hadn't got there. He said that when a nation's at war, many things that might be said in times of peace are such a hindrance to its effort that their utterance won't be endured for as long as men fight, and no court could regard them as protected by any constitutional right. Because the jury had actually determined that there was obstruction, Holmes wasn't prepared to overturn the verdict. Congress had a right to prevent obstruction. So the law had moved some way. There was a new objective test. It was untethered from bad tendency, but it had the same outcome. The second case I want to talk to was handed down by the court only a week later. It involved a very famous man, Eugene Debs. Gene Debs was the founder of the Socialist Party of America. He was a 4-time presidential candidate. He was a very well-known man. In fact, in 1920, he got over 900,000 votes from jail. Debs delivered a speech in Canton, Ohio, a very class-based speech attacking capitalists from the president down as the real traitors, who'd lain with the enemy and now demanded that the workers fight the Germans. His beef was that the workers were being forced to fight the Germans, and it was unfair. A jury convicted Debs of attempting to incite disloyalty in the military and to obstruct the draft. Now, for that little speech, Debs was sentenced to jail for 10 years. Holmes wrote for a unanimous court in upholding the conviction of obstructing the draft. He did it because he accepted that the verdict of the jury was proof of the interference. There was no great explanation. The jury was carefully instructed. They had a specific intent. It didn't make a lot of sense a week after the clear and present danger test. The two things just didn't come together. The acknowledgement was very ambiguous. Not surprisingly, there was substantial public criticism after the Debs decision, and Holmes's private correspondence discloses a concern that the case was prosecuted and a hope that Debs would be pardoned. Holmes's view was that this is the law has been given to me, I'll enforce it, I don't agree with it, but that's the law. That was his restraint view through his whole life. But there was a campaign that was waged, not just in the papers, but a very personal campaign, an intellectual campaign amongst Holmes's confidants. It was clearly designed to convince Holmes to change his mind on the First Amendment. A number of people were involved in this. They included Felix Frankfurter, who was then an academic. He would later become the Justice of the Supreme Court. Harold Lasky, scholars Zach Chaffee and Ernst Freund, Leonard Hand, Louis Brandeis. Holmes was always, of course, open to intellectual debate and any scholarly criticism at all. But this was an appeal to a man who understood more than most what war and duty was. Holmes had a black book. It recorded in fact, he had a series of black books, and the black book recorded every book that he had ever read. His black book records during this time considerable philosophical readings on free speech. He reread John Stuart Mill's On Liberty in this time. Holmes had actually met Mill at Westminster when he was a law student and apparently respected his philosophy, but had repeatedly described Mill as dull and unimaginative. In any event, the case that changed everything for the First Amendment was the Abrams decision. It was decided 9 months after the decisions I previously discussed, and there were a couple of other decisions along with Schenk and Debs which had the same flavour. In 1918, and after the Russian Revolution, the United States had deployed troops in Russia at the urging of the Czechs, because the Czechs had some stranded soldiers. They'd initially been fighting the Germans, they ended up fighting the Red Army as well. The American operations were widely seen as an attempt to undermine the new Bolshevik regime, which had already signed a peace treaty with Germany. The defendants were 5 people, immigrant anarchists, socialists of Russian heritage. They, along with 1.6 million others, had fled Russia to the US before the war on account of the Tsarist regime's anti-Semitic policies. The defendants were sympathetic to the aims of the Russian Revolution, and they felt betrayed by Wilson. So they produced 5,000 leaflets in English and in Yiddish. They rained down from buildings in New York. They were critical of American intervention in Russia and President Wilson's political hypocrisy. They just called on the workers to awake and unite. They were promptly arrested. They were charged with conspiring to violate the Sedition Act, inciting resistance to the war. One of the co-accused was beaten so heavily he died in custody. Now, as aliens who admitted to being anarchists, they could immediately have been deported, but the authorities decided not to do that. They wanted to make an example of them. They wanted to convict them under the Sedition Act. There was an obstacle, in a sense, that they weren't protesting the war against Germany, but they were protesting Russia, but that obstacle didn't stop anybody. The trial was presided over by Henry Clayton. He'd been the judiciary chairman of the House. He was a representative from Alabama for many years. He gave his name to the well-known Clayton Antitrust Act. Now, Judge Clayton had no experience in espionage cases. He ignored fundamental issues of fact. He took charge of the cross-examination. The general view was that he could have handled the trial with a little less hostility towards the defendants and directed the jury more fairly. So 17 days before the armistice, the defendants were convicted. They were sentenced, well, 3 of them were sentenced to 20 years imprisonment. The severity of the sentences meant that they got bail fairly easily because $10,000 for each of them was raised through public protest. So obviously the case was destined for the Supreme Court, which heard argument for 2 days in October 1919. The arguments made were the arguments that one would expect. And the court dismissed the appeal and sent them back to jail. The First Amendment argument was dismissed on the basis that if you could convict in Schenk, you could convict in this case as well. The argument that they were protesting the Russians rather than the Germans was dismissed on the basis that it was about defeating military plans of the government in Europe. There was much persuasive evidence, according to the court, for the jury to convict. But this was not a unanimous court. Holmes had changed his mind on the First Amendment. He'd circulated his dissent after the argument. His dissent proposed an expansive interpretation of the First Amendment that only punished immediately threatening speech. He actually received a personal visitation from 3 judges at his home to urge him to change his mind. They urged that the court be of one voice in times of crisis, that the country's resolve shouldn't be weakened. They were concerned that a dissent from a judge of Holmes's stature was not in the national interest. This was all recorded by his associate. His record of the visit said that they appealed to the old scholar in Holmes, and they even dragged in Holmes's wife, who also appealed for him to join with the uniform cause. But Holmes wouldn't change his mind. He said, in this case, sentences of 20 years imprisonment have been imposed for publishing 2 leaflets that I believe the defendants had as much right to publish as the government has to publish the Constitution they now so vainly invoke. The defendants are being made to suffer for the creed for which they avow. When men have realised that time has upset many fighting faiths, they may come to believe even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by free trade and ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out. He said, this at any rate is the theory of our Constitution. It's an experiment, as all life is an experiment. Only the emergency that makes it immediately dangerous to leave the correction of evil, counsels to time, warrants making any exception to the sweeping command that Congress shall make no law abridging freedom of speech. So from Holmes we'd had a developing jurisprudence, from rejecting the prior restraint doctrine to finally extending the clear and present danger test to something that was much closer to incitement. We'll never know exactly why Holmes changed his mind, but the evidence suggests a combination of predisposition, of study, experience, and external influences. He was predisposed towards freedom rather than restraint. He was predisposed towards a functioning democracy as a foundational ideal. He'd undertaken extensive philosophical study. He continually refined his views. He had life experience of the democratic demands of a society in turmoil from the Civil War to the World War. And he had the external influences of close confidence. In Lochner, Holmes had written that the Constitution is made for people of fundamentally differing views, and his decision in Abrams ultimately is the natural consequence of that. Now, scholars and historians have attempted to unpack Holmes's analysis within an inch of their life. Private correspondence has been deconstructed and assessed as if it was a considered judicial pronouncement. I suspect the truth isn't that complicated. Holmes was just playing the ball in front of him, as he saw it at the time. He was developing a theory. At no stage, even at the end, was that theory fully coherent. He was relying on his philosophy, his training, his understanding of legal history, his understanding of the Constitution, his appreciation of the circumstances, his appreciation of how a constitution in his mind should work. He had great instinct. He had unrivalled scholarship. We know his judgment was written quickly. And I suspect Holmes simply unloaded on something that he'd probably been pondering for 78 years. Now, other judges didn't have such a developing jurisprudence apart from Brandeis. And even Hand and Frankfurter, who later were both, well, Frankfurter was on the Supreme Court, Hand was in the same case that ended up in the Supreme Court, eventually betrayed their own First Amendment views in subsequent cases. But Holmes went consistently into dissent on First Amendment issues. And although he never formally abandoned the clear and present danger test, in his dissent in Gitlow, he went much closer to the incitement test, where he said every idea is an incitement. It offers itself for belief, and if belief is acted on unless some other belief outweighs it. The only difference between the expression of an opinion and an incitement, in the narrower sense, is the speaker's enthusiasm for the result. Eloquence may set fire to reason. First Amendment development over the years since has been uneven, but by 1964, in the New York Times and Sullivan, the court was finally unanimous. And in Brandenburg and Ohio, we have the test that we have now, that the constitutional guarantee of free speech and free press doesn't permit a state to forbid or prescribe advocacy of the use of force, except where such advocacy is directed to or inciting or producing imminent lawless action and is likely to incite or produce such action. So although the court in that case formally abandoned the clear and present danger test, Justice Douglas expressly acknowledged Holmes as the progenitor of the First Amendment ideal. So it's very hard to summarise Holmes's legacy. He's become a more controversial figure, as is our time. He was party to some decisions which clearly wouldn't be made today, most notably in Buck and Bell, a case upholding compulsory sterilisation laws, in which 7 fellow judges concurred. A single moment is not more important than a life story. The fact that decision would not be made today actually vindicates Holmes's view that societal values change, and they change radically, and they can change quickly. Holmes is universally regarded as a great judge, which is a pretty subjective judgment about elusive qualities. What is certain, whatever greatness might be, no one becomes great by acting the same as everyone else. Holmes was a unique lawyer with a remarkable contribution of attributes, each of which functioned at the highest level. He was a genuine war hero, a philosopher, a scholar, a legal historian, a poet, a Renaissance man, a realist, almost certainly the smartest person in every room he entered. He thrived on complexity. He was more interested in ideas with which he disagreed. He was not ideological or political. Even his critics described him as Alshaw of his legacy said he was the scholar and jurist who more than any other individual shaped the law of the 20th century. And his greatness also probably comes from his legacy. 30 years on the Supreme Court is a very long time. He's taught us a number of things. He's taught us that values are transient. He's taught us that the political process is imperfect, intellectually impure, sometimes thoroughly frustrating, but on questions of public policy it may be more legitimate than authoritarian solutions of experts, including lawyers. He's taught us that codification is transient. However much we codify a law, rules keep changing. He viewed cohesion as a complete fantasy. He said the truth is that the law is always approaching and never achieving consistency. It will become entirely consistent only when it ceases to grow. And he's shown us that intelligent and constructive dissent is vital. In a modern world, we need to be even more accepting of difference if individuals are to secure dignity. And diverse societies are to move forward together. Holmes tried to understand the world better and not to mould it. The United States seems to have a cultural imperative as an adjunct to its notion of checks and balances, that the Supreme Court justices are independent, but they're avowedly liberal or conservative. Holmes didn't have any philosophical agenda. In times of dispiriting public discourse, this more English approach has a lot to recommend it. Holmes retired in 1932. His seat was taken by Benjamin Cardozo. His mind didn't retire. In the 3 years between his retirement and his death, he read a further 620 books, according to his black book. He died on the 6th of March 1935, just before his 94th birthday. He left $263,000, the bulk of his estate, to the federal government without explanation. He's buried in Arlington National Cemetery. Only once did Holmes break his retirement to voice an opinion on contemporary affairs. The choice was telling, and it was pressing. In 1933, Holmes consented to become one of the sponsors of the university in exile because, in his own words, the termination of intellectual freedom in German universities constituted a challenge to civilisation. So in conclusion, I'd say that no single statement can possibly encapsulate such a long, distinguished and productive life. However, one comment of a presidential advisor at the time of Holmes's death is particularly insightful. He said, "Justice Holmes may be counted as one of the few men of his time who have believed in democracy and honestly accepted its implications." Thank you.
Lionel, thank you very much for the enormous amount of work that's gone into the preparation and the distillation of your paper tonight. It's very timely in many ways because, of course, as you say, the conflict between order and freedom is perennial. I do think, though, that we've benefited from your eloquence tonight, and that may set fire to reason in this room and elsewhere. And I hope that it will lead to further discussion of those topics, perhaps tonight and hereafter. Could I just mention before we close 4 very quick things? Firstly, the 3rd lecture in the Selden Society Australian Chapter series will be on the 7th of November this year, when Dr. Caitlin Goss will give a paper on using and proving history in constitutional cases. Secondly, could I mention to those members of the Selden Society who are present and those who'd like to be members that the membership renewals for the year are due at the moment, and if you've not renewed, please do. You can do so on the library's Legal Heritage website. Anyone who's not currently a member are very welcome to join in that same way. And for those of you who are members and those of you who are about to become members, I can remind you that the annual lunch for the Selden Society is on Friday the 26th of July, and that there are still some places available if you're interested in attending. The Honourable Geoffrey Spender will be the occasional speaker after lunch, and that in itself might be a reason to attend. Could I ask you, Lionel, if you would accept this as a small token of our appreciation of your contribution tonight? And could I ask everybody present, please, to thank Lionel and could I invite you all to join us for some refreshments outside? And thank you very much for your attendance.